Good day and welcome to a live webcast of Health Reform in the Court. I'm Mary Agnes Carey. Today, the Supreme Court upheld nearly every provision of the landmark 2010 healthcare law, and in doing so, handed a major victory to the Obama administration and Democrats. By the narrowest of margins, 5-4, the court said that a key provision in the law, a requirement that most people buy health insurance by 2014 or pay a fine, was constitutional. Not all of the law emerged unscathed. The court said states could decide whether or not to participate in the law's expansion of Medicaid without risking their current federal funding for the program. With us today to discuss the Supreme Court's ruling are Tom Goldstein of the law firm Goldstein & Russell and publisher of SCOTUS blog, Julie Appleby, senior correspondent for Kaiser Health News, Stuart Taylor, legal analyst and writer, and Lyle Denniston, a reporter for SCOTUS blog who has covered the Supreme Court for nearly 6 decades. Tom will start things off today with a discussion of the legal aspects of the ruling, and then I'll pick up with a conversation about policy and political implications. Tom, take it away.
Thanks so much. It's a pleasure to be here, of course. And we think that most of the folks who are watching are familiar with the basic decision of the court, which you summarized, and that is the challenge to the individual mandate was rejected, even if on a rationale that many didn't expect. And then the rest of the statute, by and large, with one important exception, upheld and the challenge is rejected. But I want to turn first to Stuart, who was in the room, and give us a flavor, if you would, of what that experience was like.
It was the most riveting Supreme Court theater I've ever seen, Tom. It was really dramatic, and I was glad to be there. Why? Suspense is why. Nobody knows going in what's going to happen. Chief Justice Roberts begins summarizing opinion. He goes for half an hour. 5 minutes in, 10 minutes in, they're going to strike it down, is what I'm thinking. And I think most people in the room were thinking, because he's talking about the Commerce Clause argument, and he's saying the Commerce Clause does not justify this.
What a tease.
Then, 5 minutes later, oh my God, no, they're going to uphold it. Because now he's talking about the taxing and spending power and saying that's good enough. So then he starts Medicaid, and you think, well, they upheld the individual mandate. Nobody thinks they'd strike down Medicaid. Oh my gosh, they're going to strike it down. And they did, by 7-2, with 2 of the more liberal justices joining, which is a huge surprise. Then comes the footnote. All we're striking down is the extra penalty that would be imposed on the states of taking away all their Medicaid funding if they won't go along with this. We're not striking down anything else. And then you get through 20 minutes of angry dissents by liberals and conservatives. But at the end of Justice Ginsburg's dissent, you get, in the end, the Affordable Care Act survives largely unscathed. Bingo. That's the case.
That's what everybody knew. Well, let's break it down. Let's talk about the individual mandate challenge and also the Medicaid challenge. And can you just give us some context here on how this move from the Commerce Clause to the taxing power is a little bit confusing and requires you to dig a little bit deeper into how the statute actually operates, how the mandate intersects with this tax. So can you give us a sense of that?
Well, there is this what was originally called a penalty, and now the court has said is a tax. If you don't carry insurance in 2014, you face the possibility of this penalty. There are some exceptions to it, but the penalty starts out pretty low in 2014. It's $95, but it ramps up. It ramps up to about $695 or 2.5% of income, whichever is more. So that's what is the penalty, which is now a tax. So if you don't have insurance, you face this penalty, with some exceptions. If the cost is going to be more than a certain percentage of your income, or if you have a religious exemption, there are some reasons why you don't face the penalty.
All right, and so this is incredibly important for how the statute is going to function. So the idea is this: if you don't comply with the mandate, you decide, I'm not going to buy health insurance. Can anything happen to you other than you're hit with this tax stroke penalty?
In what way?
Well, my impression from the opinion is that's it.
Mm-hmm.
That if you're willing to pay the $95 in year 1, for example, and what do we think? Maybe we'll table this for a second, but I think that's going to be the real intersection between the legal decision today and the health policy implications. Lyle has been writing through the day that this may have very significant implications if Americans go, particularly in the early years, well, maybe I just won't get health insurance and I'll pay the $95, and what that'll mean to insurers.
That's a big question. Will that be enough to entice people to sign up? But remember, a lot of people already have job-based coverage. Many people aren't going to face this penalty at all because they already have coverage through their jobs or some other way. But the question is, if you don't, is $95 or even $695 going to be enough to encourage you to do so?
Proponents of law have made it clear there's no jail time involved here.
Yeah,
Pay the
right.
Well,
penalty.
if you don't pay the tax, there
don't
can
pay the
be.
tax. Right.
One important thing, I think, Tom, is that the court, it was an integral part of the court's holding that this could be upheld as a tax to say, if you don't pay the tax, nothing else happens. I'm sorry, if you don't buy the insurance, the only thing that happens to you is you have to pay this penalty.
Right.
You cannot go to jail, you're not a lawbreaker, blah, blah, blah,
But
blah,
you
blah.
can go to jail if you willfully refuse to pay the tax.
Right,
In other
just
words,
like any tax.
Well, and that's, having pushed this over into the tax code, then the whole panoply of federal power to enforce the tax code comes into play, at least if you willfully. Now, that means intentionally you just have to say no to the IRS and you have to mean it. Then you are subject to criminal prosecution. So I think that's a very vital part of this opinion. But on the point about its impact, there were estimates, and the Chief Justice mentioned them, that at least 4 million people every year are going to refuse to sign up for health care. Now, 4 million people doing that, you know, when we're talking about a country of 300 and some odd million people, may not be a large number, but the question is, how infectious is the refusal to buy insurance going to be? You know, we can count on Republican politicians and conservative organizations trumpeting the idea that, you know, this is such a bad idea, nobody should buy health insurance.
In fact, I was out on the steps when Michelle Bachmann was saying millions of people are going to refuse. Absolutely.
And that may be true, and there's also subsidies. However, I think the supporters would say these subsidies might well entice people to sign up, because if the government's going to give you a bunch of money to sign up for health insurance and you want it anyway because you'd like to protect your family, and hey, they're going to give me money, you might as well do it.
Now,
So-
am I right in thinking that this is really at the heart of how the statute operates, that the insurers, in order to have a balanced portfolio of risk, really do need younger, healthier people to come into the
They do.
pool
They do.
and to not refuse and to not pay the penalty? They need them to
They
get
really
coverage.
need them. They're younger, they're healthier, and they're going to balance out the risk pool. So if they don't get involved, if they don't see this worth their while, and they don't get involved, that's kind of smoothing out that is intended may not happen, because you need your healthier people to do that.
The
Well,
insurers
but, you know,
breathed a real
without-
sigh of relief today about that, because they were worried the mandate was going to go and leave them with the other pieces.
Well, that's true, but maybe now the question is it a sigh, or are they drawing a little bit shorter breath? Because could this become so political? Could some sort of movement emerge? Could there be a broad-based decision to say, I'm going to take the penalty rather than getting the insurance, right? That's a possibility.
Right. Well,
Robert's,
you know, without getting too wonkish about it, remember the insurance industry went along with this after having fought it for decades, because they thought that they were going to get a guaranteed pool of premium payers. Now, apparently, this doesn't go far enough to really to empty that pool, but it may well, depending upon people's choices that will be made by millions of individuals, if Congress doesn't repeal this law in the meantime in 2014. And the question is, what is the impact going to be on that premium paying pool? And the insurance industry is probably going to have some sleepless nights between now and 2014 over just how much does this switch away from the idea that people have to buy insurance to the idea that they've got a choice whether to buy insurance or to pay a fairly modest tax penalty.
Right, it's a really interesting illustration of kind of Supreme Court optics, because the court did uphold the mandate. It did uphold the penalty stroke tax, but it puts a veneer on the case that really focuses the mind on the idea that, hey, if I don't like this mandate, or I don't feel I need insurance, or I can't afford all the insurance, what happens to me? Well, one of the things the Chief Justice did make perfectly clear is, well, you're going to pay this tax, but it's not like you're breaking the law.
But you know, the government of the United States said that in the argument.
It always
they said
did.
you should uphold this because the only consequence is the tax. The Chief Justice helps you do the math if you're wondering whether you should buy the insurance or do the tax. He says the insurance would cost you about $400 a month. If your income is $35,000 a year, the penalty is $60 a month. If your income's $100,000 a year, the penalty's $200 a month. So up to a certain income,
Right.
there's a significant advantage financially to just paying the penalty.
Right, I absolutely agree that the government's legal position here was totally clear, and that is they really wanted to try and set up this fallback tax argument. And so they said the only thing that can happen to you is that you won't have to pay that you'll have to pay the penalty if you don't get the insurance. But I think this is, now that people are looking at a decision, people are going to pay more attention to it. Nothing got struck down in this respect, but it does focus on the grand bargain that was part of the statute. Before we focus entirely on the individual mandate, which is obviously what people care a lot about, let's not forget the important Medicaid decision. So, Lyle, do you want to give us a little bit more detail?
Yeah, first of all, a little bit of history. That part of the law was passed under Congress's spending clause power. That's the clause in the Constitution that gives Congress the authority to raise or to impose taxes and to spend money. The court had not struck down any federal law passed under the spending clause since 1936. So you're talking about a long period of history in which Congress could do just as it wanted under the spending clause. Now, really, for the first time, in all of that time, the court has said you can go too far when you give money out to the states with the conditions that you attach to them. And for the first time, and this literally is the first time in history, where the court has applied what's called the coercion theory. In other words, the appeal of money and the amount of money that the government is handing you is so unavoidably attractive. You got to take it. But the conditions that are attached to it are so onerous that they'll break our budgets at the state level. And so the states say that's coercion. The Supreme Court has mentioned the coercion theory 3 times since 1936. One time it mentioned it, for example, in a program when Congress was trying to get states to raise the drinking age, and so they said, if you don't raise the drinking age, we're going to take away all your highway money. Well, the court...
I bet the kids love that.
No, the kids loved it, sure. But the court had mentioned this theory 3 times over the years, but had never applied it. And as a matter of fact, the theory was so far out there, it seemed, in terms of legal doctrine, that in none of these cases, in the healthcare cases in the lower courts, did anybody accept it. The 11th Circuit Court, whose decision the court was reviewing today, said, well, the Supreme Court says that the theory exists, but no one has ever applied it.
And then, so little was thought of it under existing doctrine that the states and the business groups, they weren't even pressing the Supreme Court to hear this question. The Supreme Court added it into the case, causing everyone to scratch their heads, and now we know why. They were serious about making something of it. And so the rule now, Lyle?
Well, the rule now is that, at least, well, first of all, on the Medicaid itself, the Congress cannot enforce the new conditions on unwilling states. If a state is not willing to do that, you cannot take away their existing allotment under the Medicaid program for the poor.
That is, if they won't take the new money, you can't take away their old money.
It's an opt-in procedure now. If a state doesn't opt in and accept the conditions, then you can't take away its access to Medicaid funds under prior programs, and that's that is a huge win for the states.
But how much weight did it have that the law gives for this newly enrolled population, that they cover, the federal government covers 100% of that cost for about 3 years, and then it goes down eventually to 90%. That's a lot of the federal government lifting that financial burden, if you will, off of the states. How did that weigh in on the justice deliberations? How much homage did they give to that?
Not much. They really drew a line that said, look, if you want to tie this money to these conditions, the new money and the new conditions, fine. But to threaten all the old money, right? So even though you may be financing 95% of it now, you're putting a threat on something that they have made all of their budgetary planning on, all of their health, not all of their, but a huge amount of health care is on the basis of it. And that just crosses a line. Now, it may not have immediate practical consequences because how many states are really going to turn down the new money, given the prominence of the level of federal funding? It would be kind of shooting yourself in the foot. So I don't know that today that a lot of states or any states are really going to, you all would be the experts, are going to turn around and say, thanks, I appreciate the hundreds of millions of dollars, but I just find that an onerous, coercive condition. But for the longer term, what do you all think about whether this could be a significant change in the law?
I think the fact that it was 7-2 to hold that this was an unconstitutional condition imposed on the states, even though, as Lyle said, none of the lower court justices bought it. They'd never done it before. But the fact that two of the more liberal justices, Justices Breyer and Kagan, agreed tells me that they're not worried that it's going to be used to unravel the federal safety net, or they wouldn't have signed on to it.
Well, but I think one of the things that we have to keep in mind in looking to the future under this is for the last several years, perhaps most of the last decade, every year in the Supreme Court terms, we get 1 or 2 or 3 petitions, that is appeals, by states saying this or that federal program is coercive and we want to be relieved from the conditions. The Supreme Court up to now has turned a very cold shoulder to every one of those. Now, the question is just how onerous do the conditions have to become? So it may be, and I think Stewart tends to believe that this will be only an occasional threat to the safety net. But I don't think we can say that conclusively at this point.
Occasional to the point of no more, perhaps, you
Yeah.
think,
So-
Stuart?
I'm betting that it won't happen again for at least 5 years, maybe 10, maybe 100.
So it wouldn't affect federal funding for highways or education, that this is not a warning to the government,
The
don't
key
overstep
is
your bounds.
The government, Justice Ginsburg, who dissents on this, points out, this is going to be very hard to administer, guys. You're talking about a spectrum. Does it hurt the state a little bit to turn down the new money, or a medium bid, or a whole lot, or a huge amount? And you've got that whole spectrum. This one, they're relying on the idea, I think, that it's a huge amount. And so if you don't have another program that comes along for them to review where it comes across as huge coercion, it's just a little coercion, I think they'll uphold it.
Well, but another thing we have to keep in mind is that the more popular the program is with the people in a state, the more the states are going to feel that they have to take part in it, and so that they have to abide by the conditions. So, and if they don't want to take part in it at all, then they won't get any of the money. But there is this odd arrangement where more popular programs are the ones that the states say, gosh, we just can't stop doing that.
All right, but let's also bottom line it again for the viewers, and that is the constitutional challenge to the individual mandate gets rejected. It's upheld as a tax, and while that might focus the mind a little bit on whether you want to go ahead and pay the tax rather than getting insurance, the constitutional challenge fails. And as to Medicaid, it probably doesn't have any practical impact today unless a state says, all right, I'm going to take my opportunity to turn down the Medicaid expansion money, which might be a little unlikely. But before we leave the legal piece of this, let's let people know whether this is the end of the line. These challenges were so incredibly serious. There are a lot of people who are in love with the statute, think it's the greatest thing ever, and a lot of people think it's the end of the country. And they will want to know, is there another round of litigation, another round of cases, or is the Affordable Care Act, as proposed and pressed by the President and passed by the Congress, is it constitutional and we're done?
How about we talk a little bit, just before we finish on Medicaid, Julie, could you talk a little bit, we were discussing about how providers in these states are going to put a lot of pressure on governors. 26 states sued on the constitutionality of health care law. A lot of people, Republicans, upset on the Medicaid provision. Could you talk a little bit about how providers are going to put pressure?
Well, like Tom said, I think it's going to be very difficult for states to say, we're going to walk away from the table and not take this money, partly because the federal government wants to hand them all this money, but partly because hospitals are going to come to them and say, we want to have fewer uninsured people walking in the door. Part of the deal in supporting this effort going forward with the health reform law was that we figured we were going to get more insured people. So if you don't expand Medicaid to more people, we are going to be very unhappy with you. So I think there'll be more pressure on the states for that matter as well.
Mississippi's saying they can't afford the expansion. Other states are saying they're weighing it and looking at it. But this, certainly to your point, this idea that they can't even pick up the remaining 10% will be too much of a fiscal pressure. Absolutely.
Sure. On Tom's point about whether or not there's going to be another round, we should remember that this was a law that was 2,700 pages in length. And since the law was passed, the Department of HHS has been issuing multitudes, reams, stacks of regulations. And some of those regulations do impose pretty heavy burdens on hospitals, other caregivers. For example, there's a whole range of regulations that tell hospitals that if you discharge somebody too soon, your benefits under federal law are going to be reduced. So I anticipate that a lot of the regulations that are being issued now to implement this statute are likely going to lead to new lawsuits.
And then we have some of the more socially divisive issues. The contraception mandate, for example, is going that set of regulations. But as to the big picture, this law is constitutional. It's in place now, and the individual mandate goes into effect in 2014. And there's no immediate prospect that I can see anybody disagree that there's a piece of litigation some court's going to block it.
No, except that Republicans in the House will say, well, they think it's constitutional. We don't, and we're an independent branch of government, and we can make our own decisions about what's constitutional.
Right, one
They
house
can
of Congress
also
actually
vote-
can't.
Yeah. They can also vote it down for any reason they please, so it doesn't really matter whether they
Right,
think
they
it's
can
constitutional.
they can try and repeal it, but it seems like, I suppose, if there's big Republican victories in the 2012 elections, expanding a House majority, getting a Senate majority, the attempt to repeal it, and then a lot would depend on whether there's a Republican president who would veto a bill like that.
Now, House Republicans are already saying that they're going to have another repeal vote after the July 4th recess, and obviously this is going to be a message for them all through the summer into the fall campaigns. It's going to be a rallying cry for the base, elect more Republicans. We can finally get rid of this law. We can repeal this law. Mitt Romney was saying today again that he wants to do away with it. So it is definitely in play in the political conversation for months to come.
But a cautionary note for everybody who's really upset about this decision today and this law is that there are parts of this law that are hugely popular. And for example, the coverage of children until age 26 is enormously popular. So I think whatever Republican efforts we see are going to be calibrated rather than wholesale. In other words, they're going to pick and choose the parts of the statute that they want to take down and not try to bring the whole thing down, because their constituencies are in favor of a good deal of what's in this law.
All right, well, this is also how the Obama administration has to kind of make its case for the law over the next few months. We know that the public opinion is split over the law, over the mandate, and they're going to be out there, I'm sure, Julie, no doubt, pressing to your point, Lyle. Look, you can already cover children up to 26 on your policy. No out-of-pocket copays, preventive care. Those kind of provisions are immensely popular, right?
They are, and the mandate is the most unpopular part in the polls, but people are also very confused about what's actually in the law. But when you poll them on these different things, and the other thing that polls very highly is the fact that insurers will have to take people with medical conditions
Yeah, pre-existing conditions. It's for people who
2014,
have
that's
conditions,
huge.
yeah.
And so they are going to face a challenge. And you also have to remember that the public was split on this law. So some people are going to be happy with the decision today and some people are not. But you're never going to make the entire public happy because it's been so split all along.
On that one point, because the conservative base has been very upset at this notion of an individual mandate being a governmental overreach, it is perhaps significant that a conservative Chief Justice was not only in the majority but wrote the opinion, and perhaps that can get people to focus a little bit more on the substance of what happened and a little bit less on the idea that this is a kind of democratic, hyper-liberal ploy takeover by the government, because it seems like that's a hard message to convey with him having written the majority opinion.
Now, you just mentioned the idea of potential future litigation. If I've got it correct, when the Supreme Court ruled on immigration, they didn't preclude future litigation as that Arizona law went forward. How did the justices speak to any sort of intersection between implementation of the health law, the regulatory process, and future litigation? Was that addressed at all?
No, it was not. I mean, one always understands that lawyers will find a way to litigate further beyond any
Is
of
their
it.
livelihood? You're applauding.
Of course, like Tom Goldstein and his firm. But that was not mentioned explicitly. It was mentioned in the Arizona immigration case, and I think that's because the court, during the course of considering that, had been apprised of the fact that they were only getting the first piece of that big legal puzzle, and more of it was ongoing. And so I think Justice Kennedy, in writing that opinion, felt a need to say that we're not closing off these other avenues in the course. So those will go forward, and the court didn't need to say that today because there'll be other litigations. And Tom mentioned one, of course, immediately. The Beckett Fund, for religious liberty, already has a half a dozen lawsuits over the contraceptive coverage. The bishops have filed a massive lawsuit over that.
Right.
So that's going to be at least probably the first round in the next round.
Okay. I wonder if we can take things maybe to the policy side for a moment. We've talked about the politics, and it's definitely been a big win for President Obama and Democrats, but it's not smooth sailing now ahead for the health law, right?
That's true. It's not, there's a lot of things that still have to happen. As we've mentioned, there's all these political implications. It's going to definitely be part of the November election campaigns, and who knows what will happen with the elections, but the elections could well decide some of the factors of this. Will Congress say, hey, you know what, we want to defund some of that, we want to get rid of some of the subsidies, we want to change some things? Will they have the votes to do that? There's all kinds of things that could still happen. And as you mentioned, there could be further legal challenges, that type of thing.
Right.
So, yes.
So how much do you think the Republican message of now, I mean, obviously the court has spoken and this is the law of the land, but how much will the Republican message of big government overreach, how will that sort of square with the benefits that consumers are getting and the things that are to come? I mean, how will the Obama messaging handle that as it moves forward?
Well, that's their challenge. They've got. You saw the president today. He came on and he gave this whole roundup of what all this law does and how it helps folks who have health conditions and want to buy coverage. How there's subsidies for folks. So their message now is to try to explain what's in this law to a public that really doesn't understand what's in it and is very confused by it. The Republicans do feel that it's overreach. They say it raises taxes. It's going to hurt growth. That's going to be their message. The Democrats are going to say it's going to slow spending over time and it's going to help these tens of millions of people get coverage. But it's all going to come down to that. And then I think, as we saw today, the discussion about should we focus on fighting this fight again, or should we focus on going forward, providing more jobs for the country, that type of thing.
I'm not an expert on this, but my intuition is that this plays in two very different ways. For Republicans, the base, folks, members who are the Tea Party, this is a real motivator. We've got to get out to the ballot box. We've got to get out there. On the other hand, those folks seemed pretty motivated. They haven't been that pleased with this president. And if you look at it instead from independents, I just have the feeling that this is a real validation. The stakes were raised so much about this law as being an overreach. It was everywhere in every newspaper, and it was thrown down the gauntlet. And for a relatively conservative Supreme Court, written by the conservative Chief Justice, this is a validation, I think, for folks who are starting to focus on whether they want this precedent again. And so I can imagine it playing for Republicans as getting out the vote and for Democrats in winning some votes.
From the independents.
Yes.
Yeah.
Well, remember that this law, in its short form title, is called the Affordable Care Act. And what I think the Supreme Court did today, among many other things, was to validate two ideas. One, that Congress has a role in making sure that health coverage is affordable for lots of people, including the poor, even though the Medicaid was partially struck down. But the other part of it is that this is an embrace of the idea of universal health coverage. And that was a very controversial idea it's been a very controversial idea at least since Theodore Roosevelt. And now Congress has undertaken to pass a law that undertakes, as at least aspirationally, to have universal health care coverage. And today the court validated at least one mechanism for doing that.
I think it's also important, I think the role of Roberts in this is very interesting. There are 4 different issues decided. 3 of them are 5-4, and Roberts is the deciding vote in all of those, and then he's writing the opinion for the other, which is 7-2. And strategically, I think he's got a decision that nobody loves, but a lot of people can live with. He's got his conservatives are mad at him for not being conservative enough. The liberals are mad at him for not going all the way their way. But one thing he gave the conservatives that I think we should emphasize is he said no more expansion of the commerce power. At least you can't regulate people for inactivity. You can't make them buy Buicks or whatever. And that is a huge deal in its own right in terms of limiting federal power. Yes, the taxing power is construed very broadly here, but Justice Ginsburg's dissent goes on and on about what a terrible thing it is that the court, meaning Roberts, has now made it impossible for Congress to regulate interstate commerce as muscularly as she would like to see it done.
Mm-hmm. So
I think there's another aspect of the chief's role here. Those of us who hang around the courthouse a lot know that this Chief Justice is very sensitive to the complaint that he's leading a partisan-driven court. He is sensitive about that. His sensitivity obviously was heightened when during the State of the Union message after the Citizens United decision on campaign finance, the chief called out, the president called out the court to their face. And so I think one of the motivating factors for the chief's movement in this case into the leadership of the court was to send his own kind of institutional, reputational message. I am going to protect this court from becoming a political football in the midst of a presidential campaign, because I'm going to do something here that cannot be labeled partisan. And that's important to him, I think.
And as the campaign goes forward, the proponents of the law will talk a lot about what it means for consumers. For example, as consumers view this, what does it mean for you if you get your health insurance at work?
And most people do. I mean, most of the people who are covered right now get their employment through job-based insurance. It's about 55% of people who have coverage get it from their jobs. So this is a big deal. Initially, this decision, I don't think, has a big impact right away on people who get their job-based coverage. You've got to remember, some things are already in effect. You can keep your kids on your policy until age 26. They can't set lifetime limits on your plan anymore. There's free wellness checkups and things like that through your plan. So those things are already in place. They're going to stay in place. The bigger changes come in 2014. When, as you mentioned, there'll be these penalty fines if you don't carry coverage. There's also fines on employers for not offering it. So if your employer doesn't offer coverage now, they might in 2014. But for job-based coverage, things stay sort of the same for a while until about 2014.
Now, what if I buy my own insurance? I'm on the individual market. It's 18 to 20 million people out there fending for themselves. What does this do for them now and in the future?
This is the group that I think the drafters of the law were really looking at, because these are the people that have the most challenges at times buying coverage. If in most states right now, if you have some kind of medical condition, insurers can reject your application entirely. You can't even get coverage. A lot of folks can't afford it. So starting in 2014, the law requires insurers to take everybody, even if you have a medical condition. They can't charge the sick more than the healthy. They can't charge women more than men. It sort of evens out some of the variations in premiums. So for that group, right now, there's some high-risk pools that can help those folks who have medical conditions and can't get coverage, but starting in 2014 is when the big changes happen for them. And that's also when the subsidies kick in, and when the states create these new marketplaces, they're calling exchanges, where individuals and small businesses can go to buy coverage.
Yeah, but there's been, up to now, some of the states have really held back on creating these marketplaces.
Well, exactly.
And particularly places where there are Republican governors and Republican attorneys general. And there is a question now, and that this act has been validated, what will those states do? Will the exchanges now start coming into being? And remember, in this law, there is a provision, if the states don't do it for themselves, the feds will come in and do it for them.
Right, so they're looking at that and saying, well, what are we going to do now? I think that's a really good question. How many of them are going to do it? And I saw a study out last week. It was a report from the insurance commissioners who were estimating that maybe about half the states would be ready by the end of 2013 when open enrollment starts. You know, they've got to have the whole thing going by January 1st. It's got to be ready to go, but they're going to start open enrollment at the end of 2013, so they've got to be ready. But that was an optimistic assessment from what a lot of my sources are telling me. So if an optimistic assessment is half of states, how many will really be fully ready to go?
Why would a state object to this? Why would they say, no, we're not going to open an exchange?
Well, a number of reasons.
Cost them a lot of money?
They're getting a lot of money from the feds. Just about every state has taken a grant to start planning for this. I think it's political. A lot of them didn't want to do anything at all to implement the health law. So they said, no, we're not going to. So that's probably the main reason. But they're going to have to look at that now. And remember, some of those regs that came out just recently said that they've got to give a blueprint to the government within 10 days after the November election about whether they think they're going to be ready to move forward with this. That's not a lot of time to tell them how you're going to do this. It's a very complicated thing. Some of them may want to do it, but it's just, you've got to get your computer systems for your Medicaid enrollment updated. You've got to create this whole new marketplace where you can shop. You've got to get those systems talking with each other and get them talking with this federal data hub that's being created that'll help determine is somebody eligible for subsidies, that kind of thing. So it's technically challenging.
Another factor here is, and I think this accounts for some of the states' hesitation, remember, this law was challenged 11 seconds after President Obama signed it in March of 2010. And so there has been this cloud of uncertainty hanging over it. And I know that the health insurance industry, they came to the Supreme Court before it took this first case, and they said, we really don't take a position on where you ought to come out on this, but please give us some guidance. Please give us some certainty, because we've got this whole law here, but we don't know whether any part of it is valid, whether we're going to have to follow any part of it. So taking away that uncertainty, at least up to a considerable degree, is going to, I think, be an impetus for some of the states to start
What's
moving.
interesting, though, I was at a conference a month ago, and there were a lot of state officials there. And in states where Republicans are in the governor's chair, some of them are saying, even if the Supreme Court upholds it, we're going to wait till the election. Because, again, that intersection between politics and policy. So just imagine if they wait until the election, and then when's their plan due? 10 days or
10 days
something
later,
into election?
yeah.
Because these exchanges have to be up. You've got to be able to enroll people by 2013. They kick in coverage 2014. And about maybe 14 states in the District of Columbia have passed the enabling legislation to do this.
Can I just, again, just to bottom line this for a second, because I don't understand the exchanges as well as I should. Just for our viewers, what does that mean? As a practical matter for how the statute operates and their ability to get health insurance, if they live in a state that is going to fall behind on the timetable for creating the exchange, what does that mean for their ability to get health care coverage, if anything?
Well, the virtue of the health exchanges is that supposedly it's a marketplace in which you have bidders. So you can go in, a group of small businessmen, for example, can go into a marketplace and shop. It's actually like an insurance mall.
It's to be competitive, right?
It's
Get
supposed to be
exactly,
competitive.
small businesses,
You'll have a
individuals.
number of providers coming in and offering their plans, and the whole purpose of it and the whole idea behind it is to have, with the competitive juices running strong, people will offer
So is
insurance
the
at lower
upshot
rates.
then? Is the upshot then that health insurance might be somewhat more expensive for them, but it's not that it's going to be unavailable or that the statute won't function in their state?
No,
Might be cheaper.
if a state doesn't do an exchange,
Yeah.
the federal government is going to run a fallback exchange.
Okay.
So folks in those states would be able to go to this federal exchange.
Okay.
And remember, if you want a subsidy, you've got to buy your coverage through the exchange. So if
Okay.
you think you qualify for that, so that is a key
So
piece
every
of it.
state, an exchange will operate everywhere. It's
Right.
just a question of whether it's going to be a state-run or a federal one. For people who are trying to figure out
Sure.
who might own a small business or who might be an employee, this dilemma, the states dragging their feet on purpose for political or whatever reasons, isn't going to stop their ability to get health insurance.
They'll be able to go to the federal exchange.
Right, and the thought is, right, you get more, instead of people buying, we talked about the individual market a moment ago, instead of you being out there on your own buying for yourself or buying for your small business, you go to a marketplace where in theory these insurers are trying to compete for your business. It's all in one marketplace. And the federal government has been very flexible with it. They really want the states to do this. They really don't want to do it. So they've been very flexible.
They've been very flexible, but at the end of the day, it looks like the federal government will be running all or part of maybe half the states' exchanges.
And what about insurers had a lot riding on this? They did not want the mandate tossed or the market reforms, the requirement that insurance be given to all applicants. And Julie, to your point about smoothing out the risk, they must be pretty happy with today's ruling.
They're glad the mandate alone wasn't tossed and that they have these other pieces that require them, a lot of other pieces that change the insurance market, but they're glad the mandate wasn't dropped. So sigh of relief on that. They're looking at a lot of new customers. Bloomberg government did an analysis a couple of weeks ago, and they were estimating that up to $1 trillion in new gross revenue over 8 years for the insurance industry. So they're happy about that. But at the same time, they also face a few new rules, right? So they've got to spend at least 80% of their premium revenue on medical
Lawyers?
care.
Oh, no.
Yeah, well, sorry. But on medical care.
You'll be a high
or
share, don't worry about
quality. And if they don't do that, they've got to give a rebate. So some of those rebates are going back. So that's one of the rules that's already in effect. And then they also are going to be held to some of these other standards that sort of smooth out the premium variations and that type of thing.
Now, employers have some things to be concerned about. If you're 50 or higher, 50 workers or more in 2014, they're going to, if you have a worker who gets a subsidy, and goes to the exchange, and you don't offer coverage, again, 50 workers or more, you might be hit with a fine.
That starts in
It
2014.
was interesting that when the Supreme Court selected these issues that it was going to consider, It was asked to consider the legality, the constitutionality of the employer mandate. They passed on that.
Why did they say that?
Well, I don't have any idea why they did it, but the reality is that the court apparently did not see any serious constitutional question in telling employers that you've got to have these new plans. And so that, some of the lower courts, none of the lower courts accepted that argument, but I assume that that argument will now be pressed in some further litigation because the court just took a pass on that. So
Well, the law doesn't say you have to offer coverage. It stops just short of that, though. But
Yeah.
it says if you don't, you're going to have to pay this fine.
Yeah.
If somebody gets a
Right.
subsidy and goes
Right.
into that exchange,
Or
then
if you've got, is it 50? Is that the cutoff?
50
Yes,
or higher,
50.
50 or
So
under,
if
you're
you've got
exempt.
48 employees and you were thinking of hiring 5 more,
Right.
you might
You
say,
might not.
maybe I won't.
No, that is the argument that it's an anti-growth policy, that it could curb that for sure. And talk a little bit, maybe we could talk about the providers. This ruling affects the hospitals, physicians, all providers of health care. How do hospitals, which are huge providers of health care, stand to fare with the health law?
Hospitals are probably happy today too because they're going to get more paying customers, right? They're going to get more people covered by private insurance. The Medicaid piece may be a little concerning to them because now it's a little more uncertain whether the full 16 or 17 million more people will get Medicaid or whether it'll be a smaller number if some states do opt out. So hospitals are pleased with that. I remember hospitals face some other financial penalties and incentives as well, as we were talking about earlier. If they don't meet some quality and patient satisfaction measures, their payments may be reduced. They're having a marketplace basket. It's a sort of inflation adjustment in Medicare reduced as part of this law. So they're facing a number of different things, but they're also facing some changes in the marketplace. They're being asked, both by this law and I think also private insurers and just the marketplace, to work more closely with doctors and other providers to be more efficient, to create these organizations where they can smooth out the care and be more efficient and keep people from being readmitted to the hospital, that kind of thing, and save money. And if with the carrot that if they save some money, they get to share in those savings. So those efforts are going to probably move forward as well. Now they're
well,
happy
and
with
also
it.
the reduction, or at least the hope for reduction in the free rider problem, where people who do not have health insurance show up in the emergency room or show up and hoping for inpatient treatment and don't have health insurance. And the hospitals, under federal law, they have to take those people at least for a period of.
You have to take them in the emergency room and
stabilize them.
stabilize
They
them.
have to
Right.
stabilize them.
And so
right?
they're-
See, that's
And I think there have been court opinions which said that the stabilization process cannot stop, let's say, after a day or two, and then send them home, even if they're not really stabilized. They've been very careful about
the
that.
Medicaid expansion was crafted to add 16 million people in Medicaid rolls. If that is not the case, if states opt out, then this will put more pressure on the hospitals, on the doctors, on the labs, all the providers that are providing this care and they're not compensated for it. So you could have an unintended consequence there of the ruling.
But is it realistically possible that any state will opt out? We're going to give you a lot of money. We're going to pay 100% of it. All you have to do is enable your citizens to benefit from the money we're going to give you. Who's going to say, sorry, it's against our
Well,
principles?
it's not always 100%. It will change,
It
right?
goes down to
It will
90%.
taper down to 90
90%.
eventually.
Up to 90.
Which is still a better deal than they get right now. You know.
90 is pretty close to
90
100.
is pretty close to 100, but those numbers add up. I mean, I'm with you.
Yeah.
I can't see it happening. But that would be the argument, that it is going to be, tens of millions of dollars for these states, plus the principle, plus the prospect of the election, and taking a political stand on this question. I don't see it happening, but I don't think it'll be beyond the pale.
Well, but remember, too, Stuart, this is not a constituency that a lot of politicians worry about. This is the poor. And, I don't suppose a lot of politicians at the state level are going to get a lot of political pressure to really take care of the poor in their states. And the states are going to be exposed to a considerable pressure on their budgets.
But this is where the
Because-
providers kick in, though. That's where the
also,
hospitals will
isn't
say,
it
The
wait a
hospitals are saying
minute.
this money,
Sure.
this money
Wait a
doesn't
minute.
go out into the air.
Yes.
It's going to make its way to us, and they may
Exactly.
have some
And I,
clout.
And that
and
may-
I
they
think
may do
some
that.
of their part of the law is designed to make the Medicaid payments that are made more generous to the doctors. Because a lot of doctors say, $60 to spend 4 hours doing a surgery in the middle of the night. Thanks, I'll skip
Yeah,
it.
that's for the primary care
uh,
physicians for 2 years. And
Yeah.
then the states have to decide, do we
Yeah.
continue or not?
But that is another issue that the law brings up, the whole primary care thing. We're going to need more primary care doctors. So that's as more people get insurance, we're going to need more doctors. So that's another issue for the country as a whole. How are we going to do that?
All right, so can I just also ask another bottom line question from the health policy experts? You may think, as a matter of politics, ideology, direction of the country, good or bad, but a good day or a bad day for American health care?
I think that it'll be viewed as a great day for American healthcare because you will get more people covered. And of all the points that Julie was talking about, how there are provisions in the law, especially with Medicare, which is a big spender of healthcare, of course, in this country, to try to make healthcare more efficient. The key will be, does it work as intended? Will healthcare costs be reduced as proponents say they will be over time? No one really knows. Can you deliver healthcare as efficiently as they think? What will it be like when a variety of providers are asked to share in a payment versus getting paid fee for service, which is what they're used to doing? That's a large part of the Medicare market. I don't know if
I agree. I think the cost things are going to be the things that we look back on and say, did they work? Because that's one of the main issues here is what happens with cost. Will spending slow? But the other big piece is, did we cover more people who are uninsured? We've got 50 million people uninsured right now. That number would be projected to grow without this. So does it work? Does it reduce the number of uninsured? And as I mentioned earlier, I think some of the biggest changes in this law, people aren't feeling yet because they kick in 2014. And because a lot of it's aimed at people who buy their own insurance. And remember, a lot of people have their job-based insurance. They have no idea how hard it is to get coverage on the individual market. So this is going to be a big change, but we won't know until 2014.
Big day for healthcare with a footnote. And so in our last few moments, why don't we talk about your impressions of how this day will be remembered in the legal community, in the historical books about the Supreme Court?
It certainly would have been a history-making decision if the mandate had been struck down, because that would have been, perhaps the biggest intervention by the court in economic legislation in 80 years. It's still a really big deal. I think it will be a signature decision of the Roberts Court and will immunize the court. This wasn't its intended purpose, but will immunize the court from a huge array of criticism that it's partisan. And there are a number of very conservative decisions coming down the road, for example, on affirmative action next term, that's going to be much harder to just criticize them as ideologues. And I think jurisprudentially, the things that Lyle have talked about will be the history of the case.
Right. Yeah, I think this will go down perhaps not as big a day as Bush versus Gore, but one of the things that we have to keep in mind around the Supreme Court is that in the internet age and the rise and pervasiveness of the social media, there was an anticipation factor here for this decision that built up the public attention for it. And so, it was palpable in the courthouse this week how much pressure there was to know what the outcome of this was. And so, and particularly with the push of social media, that elevated the importance, the social and cultural importance of this decision very, very high. And so far, at least, it's the biggest decision that the Roberts Court has made, without a doubt.
Closing thoughts?
I agree with Tom. I'll put it a little differently. I think it's going to be harder tomorrow than it was yesterday to characterize the Roberts Court as a radical conservative court, which a lot of people have been doing. Now, you can still do it. You can say, look what they did to the Commerce Clause, or you can say, first time in history they ever struck down anything, under the spending power. But on the Commerce Clause, bottom line, they upheld the mandate. Bottom line, 2 of the liberals joined them on the Medicaid. And bottom line, I don't think this is going to change the law going forward. I doubt that decisions in the future you'll see lots of radical things happening because of what the court did today.
Okay. Well, I want to thank you all for a fantastic discussion.
Thank you.
Thank you very much. Stuart Taylor, legal analyst for Kaiser Health News, Julie Appleby of Kaiser Health News, and Tom Goldstein and Lyle Denniston of the SCOTUS blog. Thank you so much.
Thank you.
And thanks to all of you for joining us today. We'll invite you to join us again next Tuesday for a live webcast at 11 Eastern Time. We'll be discussing the long-term impact of the court ruling with a roundtable of health policy journalists. And we invite your questions. Please send them to questions@kaiserhealthnews.org. We hope to see you then, and I'm Mary Agnes Carey.